Hi, my name is Kellee Parker Harris. I am a DUI defense attorney in Southern California and the founder of Parker Law Center. Today I want to discuss probable cause and reasonable suspicion as they relate to traffic stops. It is imperative that motorists are aware that the Fourth Amendment protects their right to be free from an unreasonable seizure, and in order for an officer to conduct a traffic enforcement stop, he or she either needs probable cause or reasonable suspicion that criminal activity is afoot. If the stop is in fact based upon reasonable suspicion, the suspicion must be based upon specific articulable facts, and the stop can last no longer than necessary to confirm or dispel the suspicions. In California, in order to be found guilty of driving under the influence, there must be volitional movement of the vehicle. California is not a physical control state. So if the key is in the ignition, the car is on, and even if the person had the intent to drive, that is not enough to be considered driving under the influence. The vehicle must actually move, even if it's only an inch. Beware, though, the officer does not need to actually observe the driving or movement, as circumstantial evidence can be used. Furthermore, in order for an officer to make an arrest without a warrant on a misdemeanor offense, the conduct must occur in said officer's presence. California Vehicle Code Section 4300.5, however, allows for an exception when the officer has reasonable cause to believe the person was driving under the influence, with one of the 5 designated exceptions. A peace officer may, without a warrant, arrest a person when the officer has reasonable cause to believe that the person had been driving under the influence when any of the following exists. The person is involved in a traffic collision. The person is observed in or about a vehicle that is obstructing a roadway. The person will not be apprehended unless immediately arrested. The person may cause injury to himself or herself or damage property unless immediately arrested, or the person may destroy or conceal evidence of the crime unless immediately arrested. If an officer violates a person's Fourth Amendment right to be free from an unreasonable seizure by stopping a person without probable cause or reasonable suspicion, or if the officer arrests a person for driving under the influence without observing driving and California Vehicle Code Section 4300.5 does not apply, then an experienced attorney can run a motion to suppress the evidence which was illegally obtained. This can result in dismissal of all charges.